My name is Chukwuemeka Nwokoro, the State Legal Advisor for Progressives Grand Alliance, Southern State Chapter. Sorry to put the record straight. There was no court judgment by the Court of Appeal reaffirming Prince Nnanna Ukaegbu as the state chairman of APGA in Abia State. There was no such judgment. That is a lie from the pit of hell, being paraded by Nnanna Ukaegbu to deceive Abians. That has been his style of politicking. His politics is always anchored on deceit. So there was no such judgment by the Court of Appeal affirming him as the state chairman of the party. As a matter of fact, he's not even a member of APGA. I said Nnanna Ukaegbu is not a member of APGA. Go to the register, party register of APGA. Even in that place, he's claiming that he comes from. That's his word. His name is not in the register of APGA. So I can authoritatively tell you that Nnanna Ukaegbu is not a member of APGA, because you must be a member of the party for you to now to lay claim on the leadership of the party in the state. So he's never a member of APGA. Like I said before, there was not any court judgment that affirmed him as the state chairman of. Yes, maybe to throw more light on the issue at hand. In 2014, November 2014, Nnanna Ukaegbu was suspended from the party as the state chairman of the party. He was suspended by the national leadership of the party, led by Victor May. That was in November 2014. Now he went to court. He went to Obingwa High Court and filed a suit challenging the suspension. And he got an interim order restraining the national leadership of the party from suspending him from the party. Now, in the course of that matter at the Obingwa High Court, the party filed a notice of preliminary objection challenging that suit he filed in 2014. And to put the record straight, in that 2014, in his writ of summons and statement of claim before the court, he did stated that his tenure will end in 2015. Remember, we're in 2022 now. In the suit he filed in court in 2014, he said that his tenure will be ending in 2015. Now, what really happened when he now filed that suit? The party now challenged that suit at the trial court, and the suit was struck out. Now, when that suit was struck out by the trial court, Nnanna Ukaegbu appealed to the Court of Appeal Owerri. Now, that appeal was determined by the Court of Appeal, and the Court of Appeal held that the trial court was in a haste to have dismissed that suit which he filed, because as at the time the court had that preliminary objection, that the suit itself was yet to be served on the parties, on the defendants, of which APGA was part of the defendants. It was on that note that the Court of Appeal sent back that matter back to the trial, sent the matter back to the trial court to be assigned to another judge. That was in 2018. This one happened. Now, when the matter now came back, the matter was assigned to a vacation court, because during that time, it was during time of vacation. And what Nnanna Ukaegbu did, instead of abiding, because the Court of Appeal also in that judgment made an observation And what was that observation? The Court of Appeal said, this is a suit that was filed since 2014, and that suit has not been served on the defendants. We are now sending this suit back to the trial court to hear the suit. However, we wonder what the claimant want to make out of the suit. That statement was anchored on the fact that if you want to file a suit against somebody in any law court, especially in Abia, by the High Court Civil Procedure Rules in Abia State, the lifespan of any writ of summons is 1 year. If you sue somebody and you're unable to serve that writ of summons on that person and 1 year elapse, by law, we say that that suit has been spent. In other words, it is dead. There is no life in it again. So when the Court of Appeal now sent back that matter to the trial court, Court of Appeal observed that the writ has almost been spent. It has been spent almost. So there is no life in that suit again. That was why the court made that remark and said it depends on what they want to do with the suit. Now, when we came back to the trial court again, what he did was to bring an application, an interlocutory application. Remember, I told you the court gave him an interim injunction. Now, he brought another application for interlocutory injunction before the trial court again. It was a vacation court. And we also raised a notice of preliminary objection, asking the court that as at that time, there was nothing before the court because the suit he filed has been abated. In other words, it was dead at that point. Now, we try to move the court to listen to the preliminary objection because as at that time, there was nothing before the court again. There was no reason appearing before the court because the writ of summons is the foundation of every suit you are commencing in any court of law. So where the foundation has collapsed, there is nothing left to be tried. And that was the basis of our preliminary objection before the trial court again. The trial court closed its eyes. Instead of listening to our preliminary objection, he went and granted him an interlocutory injunction based on a dead writ of summons. It was on the strength of that interlocutory injunction that the court granted to him that the party now went back to the Court of Appeal and filed a notice of appeal against that interlocutory order that was granted by the trial court. Now, it was that Court of Appeal, it was that appeal matter, which is CA/OW/26/2019. That was what was dismissed by the Court of Appeal. The question you asked me in view of the Court of Appeal affirming is no court affirmed. It was the appeal that APGA filed against the interlocutory injunction he got. That was what was dismissed. What was the ground for the dismissal? The lawyer representing the party was not in court on that date. APGA was not also represented by anybody in court apart from the counsel in court. It was on the strength of non-representation of APGA in court that the court now said, we are dismissing this matter not on the merit, but for what we call non-diligent prosecution. In other words, you filed a suit, you are not there to pursue your suit. It was dismissed, not on the merit. And as we speak, we have the proceedings of that day. Even when I went to the Court of Appeal to get the proceedings, I told them at the Court of Appeal what happened. And they were laughing and said, where on this document did the Court of Appeal said, I have affirmed Nnanna Ukaegbu as the state chairman of APGA? There was nothing like that. What the court did was to dismiss the suit for non-diligent prosecution. As we speak to you, we have filed a motion to set aside that decision of the court dismissing that suit, because the law also provides that, because we had already, the party had filed his brief of argument in respect of that appeal, and the law is that where parties have filed their brief of argument and the parties or the lawyers who are not there to argue the appeal, that the court ought to deem the appeal as having been argued. That is the position of the law. So if the Court of Appeal had adverted its mind to that provision of the rules of court, they wouldn't have, dismissed that appeal as it were. So we have filed a motion before the Court of Appeal to set aside the decision it made by dismissing that appeal. However, the dismissal of that appeal has no injury. It has no injury in any way. It never affected the leadership of Reverend Augustine Ehimere's led ESCO in Abia State. It doesn't affect it in any way. Like I said, the writ, everything Nnanna Ukaegbu did in 2014 by filing a suit, that suit is dead. Is dead. Naturally, it has died. We have also filed a motion before the trial court for the trial court to delete that suit from its court list, because by law the suit is spent and it has abated and it is dead. There is no life in it. So all the noise making by Ukaegbu, if you know him, Ukaegbu is a gold digger, he's a political jobber. Every time election is approaching, that has been his style. In 2019, he tried it. Once the primaries, the period of the primaries will elapse, he will fizzle out. He will wait for the next 4 years. Towards the time of the primaries, he will come out again. Somebody asked him, and he told that person, "This is my business. Don't you know that this is from this thing I'm doing, that is where I make my living?" That was what he told somebody. So it has been his style. We are not unmindful of this his style to disrupt the activities of the party anytime election period is coming. So we know him and we know how to handle him. So whatever noise he has been making out there, he is deceiving the masses, is deceiving the people. But at least you have heard it from the horse's mouth, from me, that Ukaegbu is never a member of APGA, let alone being the state chairman of the party. That the suit Ukaegbu is parading, from which he got an injunction, that suit is dead itself. You can't place something on nothing and expect it to stand. McFoy and UAC. That is a popular, celebrated case in law. So the injunction was based on a dead writ of summons. Therefore, that injunction is also dead, because the foundation under which it is standing is dead. So it is dead already. So we are not worried, we are not perturbed. He's only a noisemaker, moving around making noise and trying to deceive the people. Abians are wise, they cannot be deceived. So you are hearing from the state legal advisor of APGA in Abia State that all the noise Ukaegbu is making, that he is the state chairman, he is never the state chairman of the party, he is never a member of the party. The suit he's parading is dead on arrival, it's a dead suit. So we are not bothered about that suit because it is dead. Like I said, we have also filed a motion before the trial court to make sure that we bury it. When the suit is dead, fine, it is still on the court list, but we want to bury it, whereby the court will now delete it from the court list, and that will be the end of it. Well, we just filed the matter. We have not served it. From now till Friday, we will serve them a copy of the motion for them to come to court. That should be, I don't want to, because of, this is a media thing, I wouldn't want them to know the date until the time we serve them. So, but be rest assured that we have a motion to delete that suit from the court list. And when we serve them appropriately, we'll be able to make a press pronouncement for people to know exactly what is happening in respect of this suit. For now, we have not gotten a date. We'll still fix a date for the matter before we can now serve them. So that is the position.